Welcome back to the Friday 5 for September 8th, 2023. My name is Andrew Ayers. I'm an estate planning and business law attorney with offices in Edina, Minnesota and New York City. And here's a quick 5-minute video, 5 quick questions that came up this week in discussions with clients, prospective clients, and even a question that came up in a discussion with a family friend. So here we go. Question 1, does a will have to be filed when you sign it? In this case, I was speaking to a prospective client whose mother had died in New York, and he was not sure what was going on with the estate. It was a recent death, and he wasn't sure if she had a will or not. He believed she did, but nothing had been filed with the court. So he'd gone down to the local surrogate's court. He'd met with the clerk. They looked through the records. However, nothing was on file. And the prospective client then contacted me and said, clearly my mother didn't have a will. However, as I advised him, not everybody files their will with their local court or the local county. Many people move all over the country, they move all over the world, and a lot of times we're updating these documents as we go, every 2 to 3 years for many people, so we don't always file them with the court. So just because you're looking for a will with the court that you think was filed, if it's not there, that doesn't mean that that person doesn't have a will. Question 2 this week, if I'm single, do I really need a trust? Now this came up in my discussion with a family friend who is looking to redo their estate plan. They've had a very simplified estate plan over the years, but now they've had some changes in their life and they're looking at adding a trust. And so we had a discussion about whether or not a basic will-based plan makes sense or whether a trust makes sense for someone who's single. So in this case, the trust actually makes a lot of sense because if our family friend becomes sick and unable to manage their affairs, then the trust allows for what we call an incapacity trustee, someone who can step in and manage your affairs for you if you become incapacitated. So in that regard, that trust is actually a very effective vehicle for her to update her estate plan and get everything in order and also have that incapacity planning in place, because as a single person with no direct family members close by, that trustee can be a very important role going forward. Question 3 this week, does my registered agent have to be in Minnesota for my LLC? Quick question, simple answer, yes. Minnesota requires that your LLC have a Minnesota address for your Minnesota registered agent. You don't have to hire a third-party company. They can charge anywhere from $10 to hundreds of dollars a year to be your registered agent. And in fact, if you're running your LLC in Minnesota and you're renting an office, you can use your office address as the address for your registered agent. But your registered agent does have to have an address in the state of Minnesota for your Minnesota LLC. Question 4 this week, can an out-of-state person own a Minnesota LLC? So this comes from the same prospective client as we were talking, and they are setting up an LLC with 5 members. One of the members is not going to be living in Minnesota, and in fact never has lived in Minnesota, and is just providing some financing and helping out with this new venture. And the concern was, can that non-resident be a member of a Minnesota LLC? And again, the quick answer is yes, the non-resident can be a member of the LLC. There is no restriction that says you have to live in Minnesota to be an owner of a Minnesota LLC. And question 5 this week, how do I get the opposing party to show me proof of damages? So this was an interesting litigation question that came up. And in this case, the parties are in the middle of discovery, and discovery is going to close at the end of October. And the prospective client and I were talking on the phone, and they had asked the other party for proof. So in this case, they were the defendant, and they'd asked the plaintiff for proof of the amount of money they're claiming in the complaint. And they'd done this just by conversational, by having telephone calls, and by talking in court with the judge, but nothing written down, no concrete proof of what the damages were had been provided. So my suggestion was, this is the point of using discovery. You can serve discovery requests, whether it's interrogatories, which is where you have to answer questions, whether it's a notice to produce documents, where they have to give you documents, or whether it's a notice to admit or a request for admissions. And these are documents that you can ask them to admit or deny certain facts about the case. Those are 3 different types of discovery methods you can use, and a 4th method would be a deposition, where you sit down in a room with a court reporter and ask them questions. So the short answer to them was there are a variety of ways that you can get the other party to give you proof of their damages, and you want to make sure you do them in advance of trial, because if you request them in discovery and then they don't produce them, when it comes time for trial, you can argue to the judge that it's unfair surprise that you'd asked for these documents months ago, years ago, however long the case took, and they never provided you with the documents. So there's your 5 questions for this week. If you like this video, you can hit the like or the thumbs up thumbs up button below. You can subscribe to future episodes on YouTube. If you have a question, you can submit a question in the link for future episodes. You can always go to andrewmayers.com to set up a legal strategy session or to learn more information. And wherever you are, I hope you have a wonderful weekend, and we'll see you back here next week.